What is a trust accounting objection? When should you file a trust accounting objection? And how long do you have to file that objection? Here's a helpful overview and guide. What is a trust accounting? The trustee of a trust is obligated to account or provide information and records concerning their management of trust assets. The accounting must be provided to all trust beneficiaries. Typically, an accounting, whether formal or informal, is provided shortly after year-end or when significant trust transactions occur. A trust beneficiary may also demand an accounting, and if the accounting is not made, compel the trustee to account by filing a petition to compel accounting. What if the trustee won't account? First, to request a formal accounting of your trust in California, you can download a simple form here on our site. Complete the form and submit it to the trustee. The trustee has 60 days to provide a formal accounting. If they don't, or if they fail to fully account within those 60 days, then you may and likely will need to file a petition to compel accounting, which seeks an order from the court requiring the trustee to account. What is a trust accounting objection? Every trust beneficiary has the right to object to a trustee's accounting filed with the court. The objection can be based on a number of claims, including 1. Incomplete, inaccurate, false, or fraudulent trust accounting information. 2. Mismanagement of trust assets. 3. Waste of trust assets. 4. Theft of trust assets. 5. Failure to fully account for trust assets. And/or 6. Failure to make trust assets productive. Who can file a trust accounting objection? Every trust beneficiary has the right to object to a trust accounting. Co-trustees may also object to a trust accounting prepared by another co-trustee. Special trustees, so-called super trustees, might also be able to object depending on their rights in the document. Essentially, anyone who has a role or interest in the trust can object. How do I submit or file an objection? To file an objection to an accounting, we recommend that the heirs or beneficiaries contact an experienced trust litigation attorney to review the accounting and advise what objections should be made and when. The attorney will help them prepare the objection and either submit it to the trustee for resolution in the case of an informal accounting, or file it in the county probate court where the trustee resides and the administration is taking place. How is a trust accounting objection resolved? In most cases, accounting discrepancies can be resolved informally with additional information and explanation. Many accounting discrepancies result from lack of good record keeping rather than nefarious intent. When that's the case, the errors tend to be minor and resolvable, not requiring judicial intervention. When the discrepancies are more serious, beneficiaries, with the help of trust litigation counsel, will need to thoroughly examine the accounting irregularities to determine what fiduciary breaches may have occurred and how best to address them. While many of these issues too may be resolved with additional information and explanation, often the beneficiaries will need to file a petition for breach of fiduciary duty to initiate a formal process to have their concerns addressed. Filing a petition in the county probate court where the trustee resides and is administering the trust will force the trustee to respond and give you a forum and process to have your concerns addressed, either informally through a mandatory settlement conference or mediation, or formally through a trial or evidentiary hearing in probate court. How long do I have to make a trust accounting objection? Beneficiaries have up to 3 years to object to a trustee accounting, although there are some limited circumstances where that time frame can be extended or where it's limited. Those exceptions are beyond the scope of this discussion. You should talk to a trust litigation attorney to examine any issues or concerns that you have. But as an ordinary example, if a beneficiary receives an accounting on January 2nd, 2010, they should have until January 1st, 2013 to formally raise their concerns. If the beneficiary fails to file with the court within that time frame, their ability to object likely will be lost due to the passage of time. Importantly, submitting objections to the trustee within the 3 years, but not filing anything with the court, will not extend the deadline. This is important. This is why you need to consult with a trust litigation attorney if you have concerns. These are things that can be easily missed and can stop you dead in your tracks. The courts want you to be on top of things, and if you aren't, you'll lose your right to object. It's important that when you get an accounting, if you have questions, you take those questions to a trust litigation attorney who can analyze the accounting and address your questions and decide what the next step should be. What is Probate Code Section 16062? The California Probate Code governs the administration of trust and probate estates. Probate Code Section 16062 requires an annual accounting by the trustee to the trust beneficiaries. It also requires an accounting at trust termination or when a trust changes trustees. When should I contact a trust litigation attorney? Contact a trust litigation attorney the moment you suspect a trustee is mismanaging or stealing from a trust, or providing incomplete information or misinformation. Most experienced trust litigation attorneys will provide a free consultation where they can answer some of your basic questions, and you can decide then if you need to retain them. You can always contact us for a free consultation. We're happy to take your call anytime. Do I need a trust litigation attorney near me? We recommend that beneficiaries and heirs find an experienced trust litigation attorney in the county probate court where the trust is being administered. For example, if the trust is being administered in San Diego, but the decedent lived in Los Angeles, we recommend working with a trust litigation attorney in San Diego. That lawyer will be generally more familiar with the local probate court than an out-of-town or out-of-state attorney. At RMO, we protect people like you every day. Give us a call or shoot us an email at hello@rmolawyers.com. Thanks for watching.